Viewers and listeners, welcome to the weekly episode of The Law Lab. My name's Tony Carbone. I'm the managing partner of Carbone Lawyers. With me today, I've got Joseph Carbone, a senior associate at the firm. Good day, Joseph. How are you?
Hey, Tony. How you going?
And Marin Carlos, an associate, work cover lawyer at Carbone Lawyers. Good day, Marin.
Good day, Tony. How are you?
Now, viewers, today we've got a very, very interesting episode so that you understand everything about the law of work cover and transport accidents. Now, what we need to discuss, fellas, is if someone gets injured at work, what should they do, Marin?
Well, the first thing that they should do is seek medical attention, of course. And then following that, I think they should speak to a lawyer.
Okay. Joseph, if you get injured at work, there's an obligation to report it, correct?
Yes, that's correct.
Okay. So you do a notice. It goes in the claims book at work. All the employers have to have a claims book, correct?
Correct.
You fill out it. You go to your doctor and they give you an initial work cover certificate.
What's called an initial certificate of capacity. So with this certificate, it pretty much explains, or the doctor will give you a diagnosis of sorts. From there, they'll also say what your capacity to work is, whether that's no work capacity whatsoever or working in an alternative type of capacity. From there, once you have your certificate of capacity, you can lodge a primary claim form on your employer if need be.
Joe, just on that, Marin, when you're filling out a claim form, you don't rely on the employer to do it because in a lot of instances, you've got to be very careful how you describe the mechanism of injury, correct?
Absolutely. And that's what we find to be the main issue in dispute. You'll find that the insurers really want to minimise any claim payout. Their job is essentially not to pay out.
I'd also say, look, in terms of lodging a claim form, we've probably found that the best thing to do is speak to a lawyer early on as well because, you can be fully appraised of what your entitlements are. And there's also some specific quirks in the legislation, specifically regarding injuries that occur throughout the course of employment that can really be teased out by a lawyer in the first instance before having to do it down the track.
And sadly, the law's become incredibly technical in the sense that if you put in the claim form a back and then you got serious psych, you might have a knee injury. If you haven't put those injuries in there, you might have to relodge another claim, correct?
Yeah, potentially you have to relodge another claim. There is another way around it, but it gets really messy, and the best way to do it is have it on the claim form anyway. If there's any stress associated with any injury, put it in the claim form.
And Joe, one of the biggest traps of all is that these claims agents that work for work cover, they go out and employ investigators to ring up the injured person and get a detailed statement, correct?
Yes, that's correct. Look, statements have their pitfalls. In many instances, what we'd tell our clients is that lodging a primary claim form should be probably enough information for an agent to conduct an initial investigation in any event. Witness statements can, cause issues because generally speaking, people do not remember, things at the time.
Well, more to the point, they don't read the statement. It gets typed up by an investigator. They don't read it and they've slipped in little bits and pieces. I don't know if it's deliberate or accidental, but it causes problems.
It can be an issue.
Yeah, on that, you'll find that if you do give a statement and an investigator is there, the statement will have things that are unrelated to the injury.
Yeah, they'll have a slant on it, generally favouring the insurer. One of the things you've got to bear in mind, it's very rare that I say to a client to cooperate with an investigator. It's only in cases where you might have a psychiatric injury where they've got to confirm certain things and how things occurred. But my advice to the clients is if you do give a statement, don't sign it.
Yep.
Do not sign anything because then us lawyers can check it and make any necessary adjustments or amendments. But there's no obligation on the worker to give a statement.
Yeah, I guess that also ties into seeing a lawyer in the first instance. I mean, it's horses for courses in many aspects. Sometimes you might very well, want to give a statement possibly, but it just depends. And seeking legal advice out in the first instance is probably the best thing to do.
And if you're speaking to John Corrence, he'll say don't give a statement under any circumstances. All right, let's keep moving. So you lodge your claim. They've got 28 days to consider it. If they knock it back, then what?
From there, there's a process called Conciliation. It's essentially meant to be a roundtable type of discussion, very informal, where you have somebody there either from your union or from
Work Cover Assist.
Work Cover Assist who'll pretty much be there and explain the claim. There'll also be someone there from the insurer, explaining why the claim was rejected. Look, a lot of the times we have seen that conciliation can bring about an overturning of a decision or a resolution.
Well, you've got to be careful with conciliation because sometimes they make unreasonable offers and the worker's under pressure and they take them, don't they, Murray?
Absolutely. So when a rejection comes in, if a claim has been rejected, there's 60 days to lodge a request for conciliation. What we find at conciliation is the insurers come and they come armed and they come with an offer. Sometimes they come with an offer of 13 weeks, 5 weeks of pay, and medical expenses to date. What we find is in those circumstances, what happens after the 5 or 6 weeks of pay? What happens after the physiotherapy
they've
is
stitched
done?
themselves up, haven't they?
Yep.
All right, look, let's keep moving. So you've got a situation, you go to conciliation, you either resolve it or you don't. The claim's accepted, it's not. If it's not accepted, then you can go to court. Now, that's another trick. If your client's got some real good prospects of common law damages down the track, now what are common law damages in short?
Well, common law principles date back many centuries, back to the old English legal system, and it pretty much ties into the concept of somebody being at fault for your injury. Basic principles around reasonable foreseeability, whether something or an act or an omission was foreseeable by an employer and whatnot. Yeah. And that also ties in or brings in some separate rights, which are separate to your specific work cover rights regarding weekly payments and medical expenses. So,
well, Marin, under the work cover system, there's a way of getting a lump sum at 12 months, which we generally try and avoid unless you've lost a leg or an arm or whatever. Mm-hmm. Or you wait 18 months and you lodge a common law case, your application, which is made up of your application, medical reports, tax returns, and your affidavit setting out the circumstances. Now, if you do get your certificate, what does that entitle you to? Certificate for serious injury.
Yeah. So if you obtain a certificate for serious injury, now under the work cover system, it's either a certificate for pain and suffering or a certificate for pain and suffering and loss of income, pecuniary loss we call it. Okay. If you obtain these two certificates, you have permission to bring proceedings against the employer for your loss, for damages.
Okay. Now, Joe, the thing with the work cover system that's got some complexities attached to it is that, okay, to get a serious injury, the definition is serious long-term impairment of body function, which is permanent and gives rise to serious consequences. Let's break it down. Permanent is foreseeable future.
Yep.
And serious consequences, we're looking at things like capacity for work, how it impacts on your social your amenities and social life, et cetera, Now, there's this 40% test for loss of income. That is the trickiest part of the whole work cover system. What's that all about?
Well, that pretty much says that it's a strict test in the sense that if you can go back, let's say you're earning $100,000 per year or $50,000 per year, if you can go back to an alternative form of work where you're earning more than or you're suffering less than a 40% loss in your pre-injury earnings, you're not entitled to claim for economic loss. Or
that is
loss of income, essentially.
Yep.
It's a very difficult test because in a sense it penalises workers that are on less money because obviously in an open marketplace you'll be able to find more jobs for people to do that are on a lower income than somebody who might be on $120,000, $150,000, for instance.
Marin, the 40% test can be a killer because if you're on $100,000 a year, you'll probably win your case more often than not. Mm. And if you're on, say, $30,000, $40,000 a year, that 40% test can really hurt you because it's almost an in theory test, isn't it?
Absolutely.
In theory, can you do a job where you're earning more than 40% of what you were previously earning, correct?
Absolutely. And it is an absolute theoretical test. It does factor in some realistic job opportunities and there are vocational assessments that are brought in, but the ultimate test is essentially a theoretical test.
Look, you do need a lawyer and you should consult a lawyer early because there's ways of protecting yourself in these sorts of circumstances. Because the other thing too is this, if you don't accept the certificate for serious injury of pain and suffering and you want to go to court for both, there are consequences if you get to court and you do lose the argument on whether they should give you a certificate for loss of income.
Yes.
And that can be pretty diabolical, correct?
Absolutely.
And then if you get your certificates and you go through all the conferencing and there's all these deadlines and time limits and everything, and that becomes very tricky too, because what happens is the insurer will make you an offer in writing, and then if you're not happy, you've got to put an offer back, and there's cost consequences that flow from that.
I guess it's sort of ironic that the workers' compensation legislation, it's almost like the size of the Bible. It's very, very thick and very, very complex.
No, it's bigger than the Bible.
Very, very thick and very complex, and it's got a lot of pitfalls in there. And, you know, a lot of the time I just can't see how, you know, a lay person will be able to navigate all of the pitfalls in the system, which is something that I guess we have a joke about from time to time.
Hey guys, don't you think that when you speak to your lawyer, right, whoever it is, ask them what experience they've got in this area. More often than not, you'll find that in the legal practice, all jokes aside, a lot of lawyers have never been to court. I hate to say it, most of them probably have not run a case, or if they have, not many. And I think when choosing a lawyer, just like a surgeon, you really need to know what the person's track record is, because bottom line, you're not going to go and get major surgery done by someone that you don't know what their track record is. It's the same with running a trial. If you're going to go to court, you're going to run a case, it's going to be pretty intense, a lot of implications in terms of costs and your future, right? You want to make sure you got the best person for the job, correct?
Absolutely.
So I genuinely say, when you make the call, ask them, how many cases does your firm run? How many cases have you run? Do you know what you're doing? You've got to actually ask those questions. Absolutely. I mean, I don't care if people throw it at me because I've spent all my life in these courtrooms. But anyway, let's keep moving. Transport accidents. It's a very similar test. You need a serious long-term impairment of a body function, which is permanent and gives rise to serious consequences, or 30%. No one gets 30% unless you're quadriplegic, correct?
Well, it's very difficult, let's say.
Yeah.
So, Marin, in a car accident scenario, what do you do?
Well, in a car accident scenario, if there has been a serious collision, of course, take all reasonable measures, call the police, call the ambulance, and seek medical attention. But the next step from a legal point of view, call the TAC, ensure that your claim, they are aware that there is a transport accident, and see if they can give you a claim number. More often than not, they'll give you a claim number right there and then.
Yeah, it's done over the phone these days, Joseph.
Yes.
And then when they send you the papers in the mail, don't just sign them. Get a lawyer to check them to make sure that they've been filled in correctly, correct?
Yes, absolutely.
Because one of the things you've got to be careful of is they might have misdescribed how the accident occurred. And if they put you down as a person at fault as opposed to the person that really is at fault, it may damage your claim in terms of getting a payout down the track.
Tony, with respect to the injuries, if someone is suffering a lower back pain or later down the track that they are diagnosed with suffering a lumbar spine injury, but they've also got problems in their knee 4 months later, what advice do you give to?
Oh, look, I've got this general theory out there, guys. Usually when you go to a doctor, you've probably got a major injury, which could be a back or a knee. But I say to clients, look, with the doctors, just give them your symptoms. It doesn't mean it's an injury. You give them all your symptoms, and let's say you go there initially with a back, but then you'll find that one of your symptoms was, oh, my neck's a bit sore. But then down the track, when you start assessing this case, could be 12 months later, your back's settled down, but your neck's blown up. If it's in the notes as a symptom, you're covered off on causation. What's causation mean, Joe?
Causation essentially is a link between an incident occurring and your injuries in a personal injury setting.
And, Marin, it's absolutely critical because a lot of clients don't realise they go to doctors, the doctor says, oh, what's wrong with you? My back. Then they've forgotten the neck, they've forgotten the knee, they've forgotten the hip. They don't describe any of this.
Another issue we find in car accidents is that the general shock and adrenaline of the car accident occurring sort of masks people's injuries at the time, and it's very common that we'll hear a couple of days later, you know, I was feeling pretty good, and then 2-3 days later, even a week or two later, all these injuries started popping up because the adrenaline wore off. You know,
and the medication for a lot of these people, you know, getting this kind of medication, which is strong painkillers, is the first time they're on these kind of medications. So it could mask a lot of the injuries or symptoms.
And once again, like the work cover system, you're entitled to lodge a claim for damages. There's no time limit in terms of 18 months. You can lodge it when your injuries are essentially or substantially stable, And once again, you put in an affidavit, a claim form, medical reports, tax returns.
Yeah. It's got to be done within the 6 years, though.
Yeah. Oh,
Yeah.
well, your initial claim, your primary claim has got to go in within 3 years.
Yeah.
In fact, if you don't lodge it within 12 months, then it's at the discretion of TAC whether they accept it in the first place.
That's right.
Yes.
Yep. So you go, you lodge your application, they come back, they give you a serious injury. Then what? You have a conference.
Exactly right. So you're given a certificate. After the certificate, you are given a conference, and where you actually sit down again in almost a round table scenario with the solicitors for the Transport Accident Commission, and you discuss your case.
That's it, and you try and resolve it. And it's usually for pain and suffering, loss of enjoyment of life, and loss of income. Now, with these cases, assuming you don't get a certificate, you've got to go to court. That is work cover and TAC, right? Goes before a judge in a county court, and the judge decides, correct?
That's correct. They've pretty much got the discretion whether to grant the certificate or not, as opposed to either the Work Cover Authority or the TAC. They've got the final say, essentially.
And Marin, they've got to assess the person seriously injured as at the date of the hearing.
Correct. So it's not at the date of the transport accident or the date of the application. No, it's the date of the hearing before the court.
And once you get before the judge, and assuming the judge comes back and finds in your favour, you go through that conferencing process again.
That's right. That's right. So all that litigation is about obtaining the serious injury certificate, which under TAC there is no two certificates. It's one certificate.
Yeah, it's easier. It's easier. One of the things you've got to bear in mind is that the work cover system's got a lot of vagaries and cost implications and repercussions and implications. So you really, really need to do it properly. When you consider putting in a counter statutory offer, if you don't get it right and you don't get within 90% of what you asked for, you pay the costs. And if the insurer has put in an offer and you don't get more than the offer they've put in, you pay their costs. So the implications are pretty high. So it's important you get someone that knows what they're doing. Correct?
Absolutely. It becomes very high stakes once you get into the statutory conferencing and offers phase. It can be disastrous if you don't receive, right. You don't put in the right statutory counter offer.
Okay, look, guys, we're getting to the end of the show. Anything else you'd like to add? Marin, thanks for coming on board.
Oh, absolute pleasure.
Nice talking to you both.
Joseph, thanks for joining us today.
You're welcome.
Viewers, thanks for listening and thanks for watching. Go to our social media platforms of Facebook, Instagram, Twitter. Please go and have a look at our website. Go through these podcasts because you'd be surprised how important information we're giving you is. And if you don't get it or if you want to clarify things, ring us. We're very, very accessible. So contact us at Carbone Lawyers, 1800 369 888. And stay tuned and stay safe.
Don't say